welcome back. We have Michael is with us, and I believe Steve Collier. So we're gonna bring up S-188. Michael, are you with us?
Yes, I'm here. I'm just trying to manage.
Michael, do you want me to put on? Do you want me to put on S-188?
I think I'm going to have to. I can do it, I think, but I'll have to do it from the committee website since I can't get documents to come through on the email.
So, Michael, you have some changes that you wanted to run through?
I'm not really sure what's going on right now.
Sorry, I was accidentally sharing.
Okay. So yesterday, Michelle came in to talk to you about S-188, and there was discussion about the criteria for small cultivators to be considered farming. And what she has drafted. And let me see if I can put that on the screen. All right, can you see my screen?
Yep.
Yeah.
Yeah.
All right. So this is the amendment she did for you. It's striking that section in S-188 is introduced, and it provides that when a licensed small cultivator cultivates cannabis outdoors on a parcel of land subject to RAPs, meaning it somehow qualifies as farming under the RAPs. The land used for the cultivation of cannabis and the farm buildings used to dry or process the cannabis shall be regulated as farming and not as development under Act 250, shall not be regulated by a municipal bylaw, which is consistent with the existing prohibitions on municipal bylaws on farming under 4413, and shall be considered the production of an agricultural product, farm crop, or agricultural crop for the purposes of enrollment in the use value appraisal program. And then I think the condition that you were looking at most closely yesterday was this last phrase, provided that the agricultural land or farm building was enrolled in the use value appraisal program at the time cannabis cultivation commenced. So I think the concern there is, do you let new property owners, new landowners initiate cultivation and then qualify for use value, or is this provision for small cultivators about people who are already engaged in farming? Their land is already in the use value appraisal program, and that they can initiate cultivation and keep their land in use value, even though they have started cannabis cultivation.
Well, I think the issue that we have talked about is if there's a small farmer and he has put his land in the current use program, he would be able to continue in the current use program with that plot of land that they're growing, that the farmer is growing cannabis on, so that they wouldn't get kicked out of the program because of it. And I think the way this is worded now, that would allow for that. In committee, if I'm not stating that right, let me know. But I thought that was our concern. Chris?
Yeah, I do have a question. I think you're stating it right. Michael, under current law, we've already said, because I remember battling about this, that if you start growing a small license, small permitted 1,000 square feet outdoors, you don't have to remove yourself from current use. That's already the law, right?
Yeah, that was the provision that I think you yourself introduced. Yeah.
Yeah. Thank you for politely saying I haven't lost my mind. And so this is, in a sense, you might argue this is not a change, but it's more explicit, because we've already said you don't have to remove yourself from current use. I think you could make the argument that therefore we have determined it's farming. But so I just want to be clear on that. We're not actually pushing a big change. We're clarifying precisely what we mean here. Is that a fair statement?
I think that's a fair statement. I mean, you basically, in the, what was it, Act 164, said that small cultivators could remain in.
Yeah.
And so that's
the question I have, and now we're talking about this as we think about that you're already enrolled and then you become a permitted grower, and we're trying to say your life, the status of your land and the oversight of it doesn't change. So my question is a couple of things. If you're in current use and you sell your farm, the land, it's not the ownership, it's the land, right?
Yes.
it's
The
the
land.
lien.
Sorry?
The lien.
Yeah. So it is possible that I'm a veggie grower. I sell to somebody that's got a cannabis permit. They start growing cannabis and current use would flow through. And in that case, we could have a new person, new ownership, same land, same legal status.
Yes. I think that's true. I think, yes.
And I'm fine with that. I think that's fine. My question is and this is sort of political. We believe that there are concerns. I don't know if they're in our committee, but there certainly are elsewhere. I've heard that you'd have right now a field that's not in current use, not considered a farm, gets bought up for the express purpose of growing cannabis, gets a permit, and then starts to try to claim that they are outside of local zoning, et cetera, et cetera. And that we're preventing here with these clauses. No,
right?
I don't think so either.
So for a small cultivator, if they got a small cultivator license, they would be regulated as farming under Act 250, and they would not be regulated by municipal bylaws. They may not be able to enroll that land in use value if the land wasn't previously enrolled in use value prior to commencement of cannabis cultivation. However, if they buy the land, somehow enroll it in use value as ag land, maybe they grow hemp on it for a year, and then they get their cultivator license, they could enroll that land in use value.
So we're saying, if you scroll up a little bit, I think this is important, not because I care one way or another, but at least that we do what we mean to do. When you get a license, outdoors, on a parcel of land subject to RAPs. So that means you're on a parcel of land that is a farm, right?
It's a farm that meets the thresholds for applicability of the RAPs. Let's just say the one that it's you're producing $2,000 in income from the sale of agricultural products in a year. So I hope a cannabis cultivator is going to hit that mark.
But I guess what I'm trying to understand is the land already subject, like if it's not a farm, or and it's not enrolled in current use, and it's not subject to RAPs, but it's an old, it was a farm 30 years ago, and somebody comes and buys it and gets a cannabis permit and then starts growing, do they have a claim to say that local zoning, does that become a farm?
For a small cultivator, yes, but not for any of the other cultivators, because the underlying Act 164 said that cultivation is not agriculture. But now you're saying small cultivation is agriculture, is farming.
So go ahead, Mike.
So yeah, if there's a field there, and taking away all the other obstacles that could be present, they start cultivating under a small cultivation license, this would entitle them to be treated as farming. It would be exempt from Act 250. It would be exempt from most provisions of municipal bylaws. And if they somehow manipulated their field and got into use value, they could ultimately enroll in use value in time, I would say.
But there would be a delay in that, right, Michael?
In use value, yes.
Yeah, okay.
Yeah, they have to harvest their first year's crop before and generate the money before they could apply.
Yeah.
Right. Well, they've got to somehow prove it's agricultural land under use value, which is not, it's not hard, but it's not easy as well.
So I'm open to that. But our discussion, in my opinion, up until now, has not entertained it this way. It's been much more of, it's already a farm, and now you're going to start growing cannabis, and we're not changing your status as a farm. That's and again, I'm open to either way, but I think the discussion we have been having is politically much more digestible for people than the notion of a change in land use getting all the benefits of ag. And it's certainly, if we are going the route of this draft, that is certainly an argument to keep it to the small producers. Again, I would be open to it applying to everybody, but my hunch is, given how much we had to battle just to keep you enrolled in current use for your 1,000 square feet, that this applying to new land use would be tricky, and maybe we make the fight anyway. But I think this is, at least to my understanding, we are contemplating this pretty different here in this draft than we've been talking about it. And maybe we've not been talking about it right. That's entirely possible.
Well, I would just say that I agree with what Senator Pearson just said. I was under the impression that we were talking about it the old way, where you had to already be in farming in order to qualify as farming, as for a small cultivator. Because we had talked about how we didn't want somebody driving up from New Jersey and buying land and being treated as a farmer for cultivating cannabis.
All right.
And this would allow for that?
Yes. If they get a small cultivator license, sure.
And we had it different so that wouldn't happen before? Because I think
No,
I
it's been in the bill in this way since introduction.
Well,
I think we've been
Uh,
talking about it differently, Mr. Chair, but maybe we were wrong.
Well, yeah, because I was under the impression that we were trying to make sure our small farmers that are already farming would, or if they wanted to expand and get into the small plot, that they would be able to get in, make a little extra money so they could keep farming. You know, they'll farm till the money's all gone. And I don't know if we
It's-
ever did have the conversation about the new guy that rolls in from wherever, buys a small plot of land. I mean, 1,000 square feet is your backyard in most houses. And then they're farming and they're growing, a small plot of cannabis.
So it's very easy for me to change this language so that it meets what your expected intent was. I would just say something along the lines of when a licensed small cultivator cultivates cannabis outdoors on a parcel of land, comma, the land used for cultivation of cannabis and the farm buildings used to dry or process that cannabis shall be regulated as farming and not as development, not be regulated by municipal. I'm going to have to build into the fact that prior to the issuance of the license, the land had previously been used, was in use as farming, subject to the RAPs prior to the issuance of the license. And I just have to figure out how to add that into the language, but it's not going to be hard.
I mean, I agree with your opinions, committee on that. I don't think we was ever planning on the person driving in from the middle of Timbuktu and buying a small piece of land and getting a license. Brian, you haven't commented on that. What do you think?
No, I agree with both Senators Polina and Pearson. I guess you too, Senator Starr. I don't want to shut people out. At the same time, I'm very sensitive to existing farmers, and if Michael can somehow artfully craft that in here, I think that's what we want to do. I think what we want to do is take people that are living in Vermont right now and farming would be allowed the exemptions herein and be able to, as Chris likes to say, diversify and find another way to make a little extra money. So that's where I am.
Yeah, Corey?
I'm fine with moving the bill with, where Chris and Anthony are on it.
Yeah.
Well,
Chris?
don't. You're not doing me any favors. Thanks, everybody.
Well,
you can't count this one against my allotment for session here, but that's been my understanding of the conversation. So I do think politically for the rest of our colleagues, that's a much easier sell. I think if we are talking about current farmland, then I'm much more open to not only limiting it to the small cultivators, but that's a separate discussion. Michael, if we do it as we've just articulated, current land, currently a farm, currently enrolled, and you get a permit, then you can stay enrolled, you're still farmland. Do we have an equal sort of protection or an issue there where that any vulnerability, we're basically not treating all outdoor permit holders the same, and I wonder if you've considered that.
No, you're basically saying, is there common benefits or common detriments argument? These are not a protected class of people, so there doesn't need to be a heightened scrutiny of the state action. The state just needs a reasonable basis for regulating in this manner, and the state can regulate incrementally. So they don't have to treat every similar class of non-protected classes the same way, if they have a reasonable basis. And your reasonable basis is I don't want to presume your reasonable basis, but I've heard several statements that could be relied on as reasonable basis.
Can I ask I'm sorry, can I ask a question?
Sure.
I don't want to take us down on a tangent, but I woke up this morning, thinking about this for some reason. And if I'm a larger landowner, let's say I own 50 acres, I'm farming, and I decide to plant a 1/4 acre of cannabis, and I'm in the current use program, what happens? I don't get kicked out of the current use program, do I, or do I?
No, you stay in.
But that part that I'm cultivating as cannabis is not considered agriculture, so I'm changing the status of that 1/4 acre of land.
So in Act 164, you said that cultivation was not going to be enrollable, but then you said the cultivation of cannabis on agricultural land shall not disqualify the land or buildings from use value appraisal, provided that the ag land or farm building is enrolled in the use value appraisal program at the time cultivation commences. The ag land or farm building is not transferred to another owner. The cultivation, drying, or processing of cannabis is done by a licensed small cultivator on 1,000 square feet or less. So currently, that cultivated land would not kick you out of the program. And you're trying to do the same thing here, but in a broader way.
That answer your question, Anthony?
Well, it's sort of. I mean, it's confusing for me because I don't understand why we're protecting the small cultivators with what we're planning. The language we're planning to put in is to protect small cultivators from being kicked out of the program. But if I'm a medium cultivator, for lack of a better way of putting it, and I'm still going to stay in the program, even though that land is now growing cannabis, which is not an agricultural product. I'm still going to stay in that land, still going to stay in the current use program. It just seems, I'm not saying they should get kicked out. It doesn't jive for me. It doesn't make sense.
Well,
so
why wouldn't, go ahead, Michael.
I haven't been involved with the Cannabis Control Board and their subcommittees, but my understanding is that some of the subcommittees are pushing for this type of language, that they want to be designated as farming, and they want to specifically not be regulated as development under Act 250, and don't want to be regulated by municipal bylaw.
Regardless of their size.
Well, I think there are some that believe regardless of size, and some that are more focused on the small cultivator.
Right.
Anthony, why is, if you're a small farmer and you decide to grow a 1/2 acre of cannabis, why isn't that considered agriculture? It's growing of a plant.
Well, I think it should be. Personally, I think it should be considered agriculture, but I thought that under the earlier law we passed, it said that cultivating cannabis is not agriculture.
It did say that. And that's because there were other legislators who wanted it to be that way. and they had the influence.
I
So why wouldn't
can't
they-
imagine what it would be considered if it wasn't agriculture. I mean, growing plants and products. Did you ever hear what it would be considered, Michael?
So in other states that don't treat it as agriculture, it's treated as industrial or commercial use.
Well, so does the committee feel comfortable in having Michael change the wording to allow these small cultivators to stay in the program if they decide to put a small plot of cannabis in?
Yeah, this
Yeah.
is, so we pitch this, this is diversification, this is a security to diversify.
Yeah,
Are we
So-
only comfortable with the smalls at this point?
well, I think Brian raised a pretty good point that by the time these guys get going, it's gonna be late into the summer. We can see how that goes this fall. And next year, if it goes smooth and good, we'll do another bill to increase the sizes up to the 37,000. I should say 3/4 of an acre because that sounds a lot better than 37,000 feet. Boy, we're talking about a big deal here. But opening it up to larger sizes in another year. Brian?
Thanks, Bobby. Yeah, I don't know whether you guys read the email from Bryn. She outlined the 6 different tiers in an email that was sent yesterday. And at the bottom, it's clear, she said that the board is not going to offer the tier 6 in the first year, which is the 37,000. So really only the top 5 would be in play. And again, maybe I'm making too much of the 1,000 square feet. I just think if we are going to try to push this through, there are some people who would feel a lot more comfortable, if we're going to call it small cultivators, making sure they in fact are considered small. The other question that came up yesterday, and I don't know whether Michael can provide an answer or not, is there any possible peril that we're putting the Agency of Agriculture in with respect to the federal government?
Well,
I'm
Steve
gonna-
Collier was supposed to be on.
Yeah, he had to leave, I think.
So I think it might depend. So right now, the state runs its hemp program, got approval for the hemp program. And under the hemp program, when the state regulator finds any product that is not hemp, just says it's not hemp, which means it has over the 1.0 THC, etc. So then they're supposed to arrange for the disposal of the not hemp crop. So if they don't, then they put the program in peril of losing its approval. So what that is, I think, I can't speak for the agency, but when I heard that they wanted to move the hemp program to the Cannabis Control Board, I think that's one reason they want to do that, because they don't want to be the ones that is going to basically jeopardize the economic value of the cannabis crop.
And we haven't talked with the board or Pepper about Or did we? I thought he made a comment in regards to that when we had him in.
I think he did too. I don't think he was in favor.
Right. Here's another concern that the agency likely has. So, all know what equip money is, correct? It's the money that flows from USDA, NRCS to, and is state shared, and flows to the agency, and then is issued as grants, either by NRCS or sometimes by the agency itself. Well, NRCS grants are subject to the drug-free workplace requirement. And that is a condition that says no employee of the grantee can be engaged in the manufacture, production, etc., of a controlled substance. And so I don't know if that puts the agency in a position of vetting whether or not an applicant has cannabis cultivation. I was looking at an NRCS guidance document from California from 2018, where all their NRCS employees are asking questions like, if I see pot, what do I do? Says NRCS is not responsible for drug enforcement. NRCS has access to producer properties subject to the Food Conservation and Energy Act, under which NRCS is required to maintain the confidentiality of information about a producer's operation. So they can't report the pot to law enforcement, but then the drug-free workplace requirement requires NRCS in the grant agreement. They have to inform the grantee that they have to eliminate the illegal use of drugs on the property. So NRCS is going to have some problems, I think. But I'm not, and maybe the agency by association will have those problems as well.
Well, I can see where if a farmer is having a small farmer, dairy, especially a small dairy farm, is having a problem with water quality, and they call or apply for a grant to try to fix that, then an ag person, either for the agency or through natural, EPA, or maybe an NRCS person goes to the farm, then they're really could be headed for trouble, I would think. If they don't call anybody to get they make enough money off the cannabis so they can fix it without calling anybody to come. Why would an ag person have any business of going there to start with?
Well, ag has general enforcement over all the laws that it enforces. So if there's a complaint, they generally go and investigate a complaint. So they would, it could be a complaint for animal welfare, water, animal mortality, etc. They could have any kind of complaint, and the agency is basically required to respond.
Chris?
Well, we did hear a few years ago that people were complaining about the odor from hemp. And so that would apply, I guess I've been wondering why we're talking about this. We're talking about this because we're making it explicit that the benefits of being farmland are being applied. Is that Is that right?
Right. It's going to be regulated as farming. It is not
Yeah.
going to need an Act 250 permit. It's not going to be subject to municipal restrictions on siting and location and operation. And
Well,
it's
we do
gonna
that
have
for agritourism, right, Michael?
for certain agritourism, yeah. For certain
Yeah.
others, no. So and then it's gonna have a reduced tax rate. So or it's going to benefit from the same reduced tax rate that the rest of the parcel has.
Boy, you do a little simple bill to try to help out, and you certainly run into some very big questions.
Well, you also have the corresponding domino questions. Do they need license plates on their trucks? Do they get to drive the ATVs on the road, even though the town doesn't allow it because it's farming? There's all the corresponding authorities and benefits that come with farming as well.
Chris?
Well, that's the argument right there, that we have to make this only apply to people that are already in this legal
Yeah.
area, I think, and to the extent we can. I mean, because those
Yeah.
questions are already answered for that land.
Yeah.
They're already answered. We're not changing anything. I think that's important. Wow.
So I'm just curious, when that was drafted, did not this topic come up about the intersection of the feds and the state? I mean, we can't be the only ones that thought of it.
Well, what about the state supporting basically this and all the federal dollars you get? I mean, I would hope that somebody talked about this that was on the side of promoting the growing of cannabis in Vermont.
So I thought I've been very clear that I would advise persons who are going into this business to be very careful about how they manage their traditional agricultural operation with this cannabis cultivation operation. I
So that-
think the best business practice is to not have the same corporate structure
Yeah,
over both businesses.
yeah, you're
and
doing
to-
LLC.
Yeah, including a subdivision of the land so that the land for use for cultivation of cannabis is not the land that is used for my traditional agricultural production. Then you don't have the issue, right? You can have NRCS come onto your traditional land and do whatever you want, because they won't be going onto the neighboring cultivated cannabis land. But I expect that persons don't want to do that that's too difficult, that they think that that's unnecessary, that they're going to take that risk.
Would in your mind, would that have to be a sale, or could it be a lease or rental agreement of the plot of land? Would that be enough protection?
I think if you leased and then you you leased it to a separate corporate entity or business entity, I think that would probably be sufficient.
Which would be fairly simple to do. you're most of, well, no, I shouldn't say most, but some farms have mortgages and they would have to get that small plot released from their, whoever they owed the mortgage to, and then lease it to an LLC, and they'd be free from all this. And I would think that if they get any advice from anybody with a legal mind, they would be told this.
I don't know. I mean, there's so many things that I would want a business to contemplate, like your banking streams, your cash streams,
Yeah.
your debt load, your the equipment that you're using. I would there'd be so many things that I would want to have some
Advice.
right.
So we could put wording in that they could, if they were, if they leased the plot to an LLC court, they wouldn't get thrown out of current use. Or, I mean, what would the taxes be on? See, we got to get away from.
Well, I don't think, because remember, use value runs with the land. And so if you already have the land in use value and they get the small cultivator license, they can set up their business entity structure, their corporate structure for the cultivator. I don't think you need to play with that much, because use value runs with the land.
Yeah, that's true.
As long as it remains agricultural land and it doesn't otherwise trigger the development definition under UVA, I think you'd probably be fine.
So do we need to have that language in there that classifies it as agricultural? Maybe everybody be better off if it wasn't classified as agricultural, just suggested, or let them argue it out, leave it. I don't know. It's a tricky question to answer, and it's going to require a little thought to maneuver the process so that a dairy inspector doesn't go in to check the barn and he sees a plot of land growing cannabis, so he goes back and reports it. But if that belongs to somebody different, it would be pretty easy to explain. If it belongs to an LLC. So, Chris?
Mr. Chair, I'd like to be sure that the agency has really thought this through. And sometimes, and it's one of the highlights, I would say, we have Michael asking questions of Steve, and, he can well represent some of the discussion here. So anyway, that would help me, because we've sort of turned the page into a very thick book here.
Yeah.
that I thought we were on the last page of. And I don't know if others agree, but that would be my hope.
Yeah, and I'm kind of sorry I brought it up, but I think it would be worse if we voted the bill out and then it exploded like on the floor with questions. So we need to think about it.
Well, yeah, we usually try to cover all the bases on most of the questions and issues that could come up. And we usually do a pretty good job. This thing, it's should be so simple, but yet there's certainly a lot of questions it raises.
Yep.
So, Michael, have you thought about any other way that we could deal with this and not have it be called agricultural, or just leave that right out of it and let, I don't know what the other side is. If we don't call it agricultural, what happens then?
Well, it's already not agriculture underneath Act 164. So then it needs to comply with all applicable state, municipal, and federal law. So state law, it would potentially need an Act 250 permit if it triggers Act 250 threshold.
Would a small plot like that trigger Act 250?
It depends on where they're located. If they're in a 1 acre town, it could.
But it's going to be under an acre though.
Right, but it's the entire parcel and how it's used, right? If the entire acre is, because you're going to have trucks, you're going to have the dry buildings to dry it, you're going to have just, you know, some. There's potential for an acre, even if it's only 1,000 square feet of cultivation, to trigger Act 250. It's a possibility. And then for municipal law, you would potentially, if you're in a town with zoning, you would need zoning permits. You might have to be located in the area of town that's appropriate for that type of business. You might have to pay impact fees. There's a lot of things. And federal law, you still have to comply with water quality, air quality, waste, etc.
Well, they're gonna have to do that, I would think anyway, but what about exempting out under a certain size or I've got to think about ways around this, I guess, more than I have thought about it in the last week or two. There should be a way that we can craft this that would allow it. But
Has the agency testified yet on where they are, what they want to do?
Well, that's why we were going to have Steve in this morning to chat about it. So maybe they aren't too interested in it, and we can just let it go that they're going to accept it. They didn't show up to testify.
Well, he did show up. He couldn't stay past 10:15, but I think I guess I worry that we've uncovered questions that they haven't considered, even though that seems strange. But so maybe we could ask him to watch this discussion.
I can email him or call him and have the conversation this afternoon, and then maybe bring him back in. You can bring him back in sometime this week.
Yeah, that I think that would probably be the most efficient way to save us all time. And you certainly, Michael, know the questions and the issues as well as we do, if not better. So why don't we leave it that you'll chat with Steve or somebody at the agency and
Okay.
we'd have to figure out if we have Friday. Linda, do we have Friday all booked up?
I don't think so. No, there's definitely time on Friday.
Would you have time to come back, Michael, on Friday?
I think I do. Yes, I do. I'm
Yeah,
entirely open right now.
yeah. Why don't we do it that way? Then we'll set, what would work best for you, Michael?
Anytime, Friday morning's fine.
9.
When you
we have-
are you on the floor at 11?
Friday is
11:30.
Representative Partridge is coming from 9 to 9:30, so perhaps at 9:30.
Yeah, would that work for you, Michael?
That's great. Be fine.
Yeah, and we'll try to get maybe, we'll get Steve to come at the same time. Anything else, guys, on this?
Oh, I think we got quite a bit.
Yeah, really, we opened up a nice can of worms.
And it wasn't a small can either. Okay, we were gonna run over 278. Is that what you had on schedule, Michael?
268. Yep.
Or 268?
Mm-hmm.
Yeah,
So should I begin?
sure.
And Linda, is that up on the committee page as well? So that because I think I'm gonna have to get to it through the committee page.
Yes, it is.
So before I go into the walkthrough, just some background. Most, if not all, states in the country have what is called a right to farm law, which is basically intended to protect farms that have been in operation from nuisance suits and sometimes trespass suits brought by neighbors when the farm has met some certain conditions, usually that they're operating in compliance with law, or they've been operating for a specified period of time, or they're engaged in certain activities which are designated as farming and deemed to be protected from suit. The right to farm laws in every state don't prevent neighbors from bringing suits. It basically provides how the court responds to certain types of causes of action. So you might hear from constituent farmers that the right to farm law in Vermont isn't working because farmers are getting sued. That's not really how it works. It's not a bar to litigation. It's how a court rules on a claim, and it's fact specific. You have to look at whether or not the criteria in every state is being complied with in order for the right to farm protection to apply. With that said, Vermont's right to farm law is fairly different from the right to farm laws in other states. Instead of the nuisance or trespass action being prohibited if certain conditions are met, in Vermont, the farm has a rebuttable presumption that the farm is not a nuisance. if the certain conditions are met, and those certain conditions are, it's conducted in conformity with state, federal, local law. It's consistent with good ag practices. It's established prior to surrounding use, and it's not changed significantly. But it can be rebutted. So even though there's this protection, the person that's alleging the claim can say, no, the protection shouldn't apply because, and the way that they rebut the presumption is that they show that there's a substantial adverse effect on health, safety, or welfare, or that the agricultural activity has a noxious and significant interference with use and enjoyment of a neighboring land. So that is different. That is a less protective standard, arguably, than the standards used in other states. And so what S268 does is it implements a standard that is more similar to states like Arkansas, Michigan, Oregon, than the current Vermont law. And I didn't draft the current right to farm law, but I was here in kind of the aftermath of it and why it was drafted this way. It was drafted this way because the original Vermont right to farm law was based on an Iowa right to farm law, but the Iowa right to farm law was challenged as a taking, and the court held that it did constitute an unconstitutional. It was an unconstitutional taking of neighboring property to a farm, and so Vermont, having modeled itself on Iowa, made some changes that were similar to what Iowa did, but not the same as Iowa. It probably went even further than Iowa in reducing the protections afforded to farms. So that's why Vermont is something of an outlier. It's Iowa and Vermont have that ability to rebut the presumption. Most of the other states don't have that type of standard. And so that's what you're looking at. I can, in preparation for this discussion, and because I like to give our paralegals and interns work to do, I had our paralegal compile the right to farm laws in about 30 states. It's almost 300 pages long. But when you read through it, you see, that Vermont does have a standard that's not used in any other state. And it definitely doesn't go as far as others. And the example that I use is Oregon. In Oregon, as in many other states, it's not just a right to farm, it's a right to farm and forest. And it applies to nuisance as well as trespass. Unless in Oregon you kill somebody in the activity. And so in Oregon, it was a right to a forest. They were helicopter harvesting, including helicopter treatment of pesticidal treatment of a forest stand. And the helicopter malfunctioned and sprayed a residential community. Right? That is protected in Oregon. That is protected because it was rightfully defined as for forestry activity, because that is forestry in Oregon. It wasn't because they violated the law. They were following good practices. It's just equipment malfunctioned, and that is actually in many states the fact that the issue arises from equipment or a malfunction is also covered. And so the residential community didn't have a cause of action because no one died. And that is kind of that's the kind of the scope the prism you're on of the way that states can regulate right to farm, and it's a pretty emotional issue in some of these states because I remember looking at Louisiana about 10 years ago, and they were going to ban everything. They were like, nobody can sue our farmers anymore because there had been a couple of cases where like longtime farmers had been found to be liable to new neighboring properties. And that was very emotional to the farming community in Louisiana. And they were going to ban everything. They didn't ultimately do that, but that's kind of the situation you're in right now. I know that there's a ongoing litigation that raises similar issues. This wouldn't apply to that ongoing litigation unless you made it retroactive, and even then a court might not recognize that retroactive effect. But that's the background on this bill. And so I'll now start stepping through the bill.
Well, it's pretty broad and so
I would say that this bill, the way that it's drafted, it's in the more common type of right to farm law out there. When you look at states, this is more commonly what you're going to find rather than the Vermont model.
So the new draft that you're going to talk about is much different than our present right to farm law.
Yep. It has some significant differences.
Yeah. So you can emphasize those as you go through it?
Sure.
Yep.
So can you see the screen?
Not yet.
Okay, hold on a second. How about now?
Yep.
Okay. So it would amend the existing right to farm chapter, which is in Title 12, which is in the court procedure title, because this relates to how a court will address a nuisance claim against the farm. The first major change is that instead of the activities that are being protected being defined as agricultural activities, the term is now being used as farm operations, and you will see later on that farm operations includes agricultural activities, but it is broader than the current definition of agricultural activities. So there will be additional activities that will be protected. And you'll see the purpose behind the right to farm law. It's not changing. It is basically because farming is a major contributor to the economy, and that its welfare and sufficiency is a state interest. That in order for the industry to survive, it will have to adapt and adopt new technologies and change, and therefore, because they're potentially subject to lawsuits based on the theory of nuisance, that they should be have some protection from nuisance lawsuits. So then you get to the definition section. You'll see the existing definition of agricultural activity. It's not changing significantly, and it's things that you would normally contemplate as farming: Christmas tree production, maple sap, horticultural and orchard crops, livestock, greenhouses, maple syrup, principally produced agricultural products, preparation, tilling, fertilization, planting, irrigation and harvesting of crops, the handling of livestock waste, etc. So also adding farming is defined under Act 250. So some of the additional activities that are farming under Act 250 would also compost production on small farms, energy production from farming. So those would also be considered farming for the purposes of the right to farm protection. Then you get to what is a farm operation. And it lists out specific activities that would be considered farming and then subject to the protection. So roadside stands, noise, odors, dust, fumes, and other associated conditions, composting, ditching and subsurface drainage, handling of livestock waste and byproducts, operation of machinery and equipment necessary for a farm, movement of vehicles on a roadway, field preparation, and ground and aerial seeding and spraying, on-site storage and application of ag inputs, use of alternative pest management, storage, transport, and application of farm byproducts, including manure or agricultural waste, and conversion from one farm operation to another farm operation, and the employment and use of labor. So those would all be farm operations, the activity or the conduct of which would be protected under this.
Michael, are they similar in other states or to our old bill?
This is basically the Arkansas definition of Arkansas or Michigan definition of farm operation. I can't remember which.
Yep.
Then you come to 5753, and this is the protection from nuisance lawsuits for farm operations. You'll see the existing law, which is being struck out. It includes that the protection is afforded when the ag activity is conducted in conformance with federal, state, and local law, consistent with good ag practices, and is established prior to surrounding uses and has not significantly changed. And then you'll see the presumption that can be rebutted. And so that's page 6, line 8 to 11. That's the fairly unique language in Vermont's right to farm law. So what it would now be under S268, and as it is in many states, a farm or farm operation shall not be found to be a public or private nuisance under one or more of the following. So it's one or more of the following. So these are not an and. It's if the court finds one or more of these, then it's not a nuisance. It existed before a change in the land use or occupancy of land and proximity to the farm. And if before the change in land use or occupancy, the farm or farm operation would not have been a nuisance. The next is the farm or farm operation is in good standing with the Secretary of Agriculture under the water quality law, meaning it has no enforcement actions against it. The next is the farm or farm operation has been conducting the ag activity at issue for 2 or more years prior to the date a nuisance action is commenced. In determining the duration of an ag activity, the initial date of operation shall be when the ag activity commenced on the farm or farm operation. And then there's another subsection that says a farm or farm operation that is conforming with state and federal law shall not be found to be a public or private nuisance as a result of any of the following: a change in ownership or size, temporary cessation or interruption of farming, enrollment in governmental programs, adoption of new technology, or a change in the type of farm product being produced. So that you don't see a presumption that can be rebutted here. It's not a presumption that they shall not be subject to the nuisance law. But I do want to note that this is all fact specific, right? Is it because of a change of ownership? Is it because you temporarily ceased or interrupted your farming? Is it because you adopted new technology? Those are all things that a court will look at. So again, as I stated at the beginning, this is not a bar to litigation. It's a directive on how a court deals with a claim of nuisance against a farm. They will look at the facts and determine whether or not the criteria is met to say that the nuisance suit should not be found, or nuisance should not be found.
Is that used in, is that the Arkansas or?
Yeah,
Michigan?
it's Arkansas, Michigan, same general structures, Oregon. It's most of the states, this structure. Some states have a little bit different. Some states like Iowa kind of build in, like, maybe if you can show that there's a significant adverse effect, that you can still bring your nuisance. But most states, this is it. This is, if you show that you meet criteria similar to this, then the court says that there is no nuisance. And in some states, it's nuisance or trespass, which is something you might want to contemplate or not, because if a person can't bring a nuisance claim, they still probably have an option to bring a trespass claim.
Do you have an example of that, Michael?
Of a trespass claim?
Yeah.
Well, I think I won't use any current action, but a few years ago in Franklin County, there was a custom applicator of manure whose equipment broke, and the manure was being applied at excessive levels, and it ran across the land.
Yep.
Into a ditch, ran into that ditch, and then across the neighboring residential property owner's property. That is trespass. And so if trespass had been protected under this law, they would have to look at the facts. But there's potential that activity would not be subject to a trespass law if you made this applicable to trespass.
Yeah, and of course, I believe since that time, we put in buffer strips and all of that, so that should help in cases like that.
And
Yep.
another part of the bill, which is also very consistent with other states, is that if there's a nuisance suit brought in which against a farm, and if the farm or farmer operation prevails, the court shall require the plaintiff to pay attorney's costs and expenses reasonably incurred by the farm or farmer operation in connection with the defense. That is not currently in Vermont's right to farm law. It is a very common component of other states' right to farm laws.
Yep.
And again, the bill would take effect on passage. It would not affect any ongoing litigation.
Yeah, so there are comments from the committee about getting witnesses in to move forward, or does the committee decide they want to move forward with this? Corey?
You know, I obviously do.
Well, the other, I can't see, of course, the other members, but
I'll stop sharing. Sorry.
yeah. Thanks, Michael. Brian?
Yeah, I think I'd like to go ahead with it too. I'm wondering if, Michael, you mentioned Michigan and Oregon and some of the other states. Where would this put us in terms of the whole country? You know, is it a more restrictive than most states or less restrictive? And, you know, obviously we'd have the agency come in and talk about it, and whoever else we thought.
I think it would put you in kind of a Common Core majority.
Okay,
It's not, there are different variations out there. But as I said, I use Arkansas and Michigan, but there are other states that are very, very similar to this.
okay.
Anthony, you got any comments?
I'm willing to take a look at it more. My question is whether it's needed, whether we need to do this or not. I'm not opposed to the idea, but I would be more than willing to listen to more testimony and get an idea as to what problem we're solving.
Well, the only thing I can really think of is as properties are sold, which many of them are being sold
Yep.
to whoever. I think as people move to the out into the rural parts of Vermont, they're gonna bump up against our 400 or 500 farmers that we've got left. And, I think some of these folks are coming from places where they've never had to experience living beside a farm. I've certainly never experienced the way farms operate, and they usually have plenty of money. And so the first thing they do is run to a lawyer, which I think we have an abundance of in Vermont. And then there's a lawsuit brought. And so it's just for general protection. I don't know, maybe we could even find out how often our old law was used. Is there any way to check that, Michael?
I actually anticipated that as well. I had some research done on some of the cases that were brought. I haven't had a lot of time to look into that, but I can look into that and send you some of those cases.
Does it look like a lot or?
No, it doesn't.
No.
From what I'm looking at, there doesn't seem to be any Vermont cases here.
Yeah, so it's light, not used a lot. Chris?
Well, my sense is that those lawsuits don't go far because, when you move into a farm next to a farm, they are protected by our current law. So I'm open to understanding this better. I'm not clear on the problem we're trying to solve. And I guess for those of you that are enthusiastic, I do think there's a risk that actually by the time we get through the process, we've moved in the other direction, because there's just a lot of issues around some of this dynamic. And I also would want to understand, by changing definition to farm activities, we have allowed for limited on-farm businesses that are ancillary, and we have, this committee pushed that to help farmers make money, but we have to recognize that we have brushed up against, I think, existing businesses, whether it's inns or facilities that offer weddings and stuff, and I just get a little nervous because we also have to be fair, I think, to those businesses and the hurdles they have to jump through. And so I'm open to it. I'm not convinced it's something that we may like the outcome of if we really dig in. And we don't have the bill, so that is a little unusual, but just point that out.
Well, I don't know. The bill is where, in Sears committee? And has he held any hearings, do you know of, Michael?
Not that I know of. I can check.
I don't think he has. I mentioned to him maybe twice that he ought to move that to our committee, and then we'd send it back to him. He could review the legal parts of it, and we would tinker with the qualifying parts. Well, I just think that it would be nice to know more, hear more about this from farmers that are they're on the edge of communities, where the community is moved to the farm. I mean, when we first passed this, it must have been 25, 30 years ago. And do you know when we did that, Michael? I think was Sam doing it back then?
Yep, it was Sam and Eric back then. And it was 2001, I think, but I can check.
Michael, wasn't there a big brouhaha over an apple producer down in Addison County?
Yeah, there's the case Trickett versus Ox.
Yeah, that's the one that I remember the most.
And the court found that, I'm going to have to go back and refresh my memory on Trickett versus Ox, because there were a couple of different decisions on that. It was first added in 1981, but this significant amendment was 2003.
Yeah, so
No.
20 years and then 20, now it's
Yeah.
20 more. So
Yeah.
it's time to probably update the thing. But that I don't remember what in the heck happened back there in 81 when we did it the first time. But there was something that happened, and but to get back to your point, Chris, this isn't trying to fix anything. It's just trying to keep a law that's been around for, well, 40 odd years, trying to keep it up to date and somewhat accurate with the situations that we face now compared to back then. But if you can be proactive rather than reactive, it's I've always found that to be better. Other questions for Michael? No. Has the House talked about any of this, Michael? Do you know, or do they have a right to farm bill over there, or is it just on us?
I don't believe that there is a right to farm bill in the House.
I thought Harvey had one.
Oh, that's right. He did. You're right. Yeah.
Harvey Smith has a bill over there, Bobby.
Yeah, Harvey does.
Yep.
Yeah. Is it similar to yours, or?
I believe so. I think we drafted this one to match that one.
Yeah.
Ooh.
I need to talk to Sears some more anyways, and before, we aren't gonna hold a hearing and not have control of the bill. I mean, that wouldn't be right. And Friday, we have Carolyn coming in, see if that bill went to her and what her take is on it from their point of view. So are there any other questions for Michael? Or Michael, do you have anything else? Yeah.
I have a couple of things. So the UVM letter, the letter to UVM regarding extension, there was a paragraph in there referring to the amount of money that was going to be going to them. I need more detail on that. I need more detail about how much money is going to UVM and how much is going to be available to extension for staffing. Or I can just remove that paragraph altogether.
Well, it isn't, I don't know if it's necessary to have it in there, but we have talked about doing $10 million more to UVM and 5 million more to the state colleges. And I almost think that's in the budget adjustment, but if it's going to their base amount, then extension gets 20 odd percent of that. I think it's 25, but I'm not. And
So maybe I should just talk in generalities then. Maybe I should just say the appropriations committees are currently reviewing appropriations for UVM and hopefully intend to provide additional funding. At least 20% of that additional funding should be used for UVM extension, and we would like you to dedicate that in part to staff or something like that.
What about if we reference the governor's recommend? Because
yeah,
I think that's what it is. And that
yeah,
way we can say something like the governor's recommended this. We want to be sure that X and Y but it would be important to know if it was moving in budget adjustment. So can you check with JFO or
Yep.
somebody for those?
Stephanie would know, sure. And I would use generalities, like a portion of that should be going to extension, and hopefully they would use that to increase staff members where needed or something, kind of general.
Okay.
So the other suggestion I had yesterday, Michael, was you referenced the hiring in the 5th paragraph, I think. I thought maybe it made sense to push it up to more like the 1st or 2nd paragraph, since that would show that we were more concerned with that than some of the other things.
So I did that. I had to rework the flow of the letter a little bit, but I did that.
All right, thank you.
Michael, I apologize. I didn't see the draft, but do we, since we heard from Mr. Bickford today, I don't want to, it at least has to be consistent with the fact that we've had that conversation. I don't know if you want to address it or not.
What was the conversation?
Well, it was about the timing for replacing some of it. And so essentially, he made it clear that he's got to deal with their process, but we're kind of saying we'd like the process to go faster nonetheless, right?
Right.
Yeah.
Yeah.
Okay.
He focused a lot on saying that they were looking for a faculty person. Is that what the phrase he used?
Yep.
As opposed to a staff person. So they're looking for somebody with tenure, somebody, really an excellent researcher who would be published and whatnot. And that's going to take a longer time than if they were just hiring a staff member.
And I didn't realize that our present guy was on the faculty up there, and with a list of degrees as long as your arm. But anyways, I think I thought he did a good job explaining, and he's only been there a few months, the process that he's gonna have to go through. And he did assure us that they were gonna hire a person, a new person, and have them on board when.
They may,
Yeah, by May, so, you know, they must have heard the same comments that we've heard, and from people from Madison County. Anything else, from members?
nope,
No, Michael, anything else?
Steve Collier just emailed. He is on a college visitation trip with one of his children. He's not going to be available to talk about the S-188 until next week.
Yeah. Well, we'll, if he's gonna be back then, we'll plan on it for Tuesday.
Okay.
Anything else, guys?
also,
Yeah, well, thank you,
Good.
Michael, and we'll see you on the floor at 1 o'clock.
yep.
But